Good afternoon, Mr. Čorej. You are appearing as a witness in this case, called by respondent. You have a statement in front of you. Can you please read it aloud?
Vyhlásenie svedka. Slávnostne
Witness statement. I solemnly swear an oath to saying the truth, nothing but the truth and the whole truth.
Then could you look at the second document in the pochette? It's R0247. It's a document of November 24th, 2004. It's a letter from you to the Ministry of Economy. And it says, "Dear Minister, I have taken the liberty to address you in the matter of arrangement of a meeting of the foreign companies represented by Čorej and Mondo, represented by Mr. Keller, who authorized me to arrange the meeting with you. These companies do business in the mining sector. In particular, they belong to two most significant companies in extraction, processing, and sale of the talc raw material in Europe." Then you go on to say they expressed an interest in the talc deposit in the eastern Slovakia, in the locality of Jamerska Paloma. You go on, the presence of which have been known already for several years. They unsuccessfully tried to acquire this deposit in 1990. Currently, the excavation rights to this deposit are owned by the company Roseman from 1997. Works on this deposit were commenced in 1999, and subsequently, due to the lack of funds, they were discontinued in 2001, and this situation lasts until today. So why are you writing to the government to discredit us, Rosman at the time?
Neviem, čo je na tom diskreditačné.
I don't know what is discreditation about this. These are mainly fact based on truth. Facts based on truth.
First, I would like to come back on an issue that a declaration you made. You said that I continued to follow the project, was close to my heart. Can I add that it was also close to your pocket and to your bank account, that you had also financial motivations, some greed? Would you agree with me that also you...
No.
So it was purely emotional, purely sentimental, your approach?
Jedinou mojou snahou
My only effort was to open the deposit, which I've succeeded doing.
Okay, but from emotional, you have feelings towards talc and this project in particular. It's no financial considerations, correct? That's how I should understand your testimony.
nie.
No.
I will go back to this letter, R0247. You said in response to my inquiry that I said the truth to the minister. And I have two questions. One is that, assume it's the truth. Why are you writing to the minister to discredit us? Even if you think the facts are true, why are you writing to the minister?
Ten list je písaný vlastne
The reason the letter was written, because Mr. Keller asked me to do that. It was not my own initiative. This gentleman had expressed interest in this deposit. He wanted to meet the minister, and he asked me to try and organize a working meeting. He would like to attend. That's all I can say to this.
But that's the upper part of the letter. My question is from the last paragraph. Why do you make that statement that works on this deposit were commenced in 1999, and you add subsequently to the lack of funds, they were discontinued in 2001, and this situation lasts until today? Why are you making that representation?
Pretože je to pravda.
Because it's the truth, or it was the truth at that time.
Understand? I understand, and we'll get to that. But I'm asking you, why are you bringing this issue to the attention of the minister? Why are you notifying of a default situation that you're...
Pretože to bola pravda.
Because it was the truth.
Yeah, but it's because the truth. I mean, is it your business to write to people to detect the truth? Are you an investigator? Are you a philanthropist? I don't know why. Why are you doing? And I suggest to you that you're doing it for the government to start a process to take it away from us and to give it to you and Mondo. Is that a fair conclusion?
Veľmi nesprávne.
Very incorrect. I disagree.
Okay, then tell me, why are you bringing to the attention of the government that we are or may be in default? What is your objective by doing that?
Pretože to
Because it was the truth.
But that answers the second question I'm going to ask you, whether or not it was the truth. I'm asking you why you are bringing this truth to the attention of, this alleged truth to the attention of the government.
Because it was my personal decision.
Okay, personal decision to snatch that mine from Roseman and to get it as you ultimately succeeded in doing. It's the facts. You triggered the process, they revoked our mine, and you got it. You triggered and you were beneficiary of this.
No one removed rights from Rosmin. Rosmin did it themselves by not performing excavation activities for which they had a license.
Sir.
Jaký bol môj
What was my impact on their lack of work? What was my fault by working hard together with my miners, not getting paid for it? I had to make redundant 100 people. 300-400 families were put on the floor.
You're sour. That's what I was going. You're sour. I'm asking you for an event in 2004. You signed the protocol. You moved on. And you go back. You have never recovered from that period. I'm here, 2004. Be with me, 2004. I move on to the next question. What makes you think that the situation that you describe is lasting until that day of November 24th, 2004? Based on what information you draw this conclusion that works on this deposit were discontinued and this situation lasts until today? And don't tell me you're talking about extraction. You say works were discontinued and last until today.
Because it is the real truth, or it was real truth at that time.
You just mentioned that Siderit approached you, inquired. That suggests that Siderit may have concluded or may be about to conclude a contract, and in fact did, at the time you mentioned, enter into contract, receive down payments. It has been working since September of that year on specific orders. It had no bills outstanding. It had no allegation of the sort you raised that you had when you were the contractor. So I ask you again, why are you saying that the works were discontinued at the time? Is it an error or a lie?
It is truth, the works were discontinued.
Myslel som tým.
Of course, I meant works on making accessible the deposit, which was necessary for mining to begin.
That's not what you mean, because listen, you say works on this deposit commenced and subsequently were discontinued, and this situation lasts until today. You're saying that there are no works undergoing. So the situation lasts today. You use the term works that have been discontinued. You're saying this thing is idle.
Certainly, but I had in mind, as any mindful miner would, not being familiar with the issue and that deposit, is not going to play with words with me, imagining something else other than excavation for the purpose of exploiting talk.
But the Citerate, well, I can't let that go, sir. You say the situation has been discontinued, but there is a contract in place with that objective set. That objective may not have been met at the time, but that contract is in motion, there is a down payment, works have started. Maybe they are far away from your definition of the 2002 amendment, which I don't leave aside a minute. But works intended to go to that direction are ongoing. Were ongoing at the time.
Otázka, jaké práce.
It depends what works were underway, because the most significant moment on this deposit was the high power line. At that time, when allegedly Čorej was present, the line was in our ownership, and I don't know based on what they would have conduct what kind of work without having access to electricity. If they conducted this using diesel generators, it's in violation with the brief and environment, because it's a third-degree water source protection area where there are very strict measures applicable. We're handling petrochemical products. So I'm convinced that without the high power line, it was not possible to initiate or to continue drilling for the purpose of achieving or reaching, rather, the deposit as declared by Rosmin.
Could you look at paragraph 29 of your statement? You say in March 16th, 1998, you let go of, you say we concluded for the purposes of realization of this transaction, contracts on the transfer of shareholding interests from the individual shareholders of Rumamorin to EuroGas, which had thus become the holder of a 55% shareholding in Rumamorin. And you say the shareholding interest was sold for £1 million. But you received $1,500,000 over 500 Deutschmark on March 23rd, 1998. Turn to Exhibit C284. It's in the pochette. This is an acknowledgement of receipt of $1,550,000 Deutschmark as consideration for the sale of 56%. I think it should have said 55% member share in Rumamorin. It's a C284 in the pochette. It should be there. It is not. Here it is.
This is C284 you just handed them?
Yes. So you...
Counsel, before you ask the question, we're going to get the exhibit for our side too.
Yes. Yes. May I? It's good? So you may wish to amend paragraph 29, say you received not 1,000,000 crowns, but 1,550,000 Deutsche Mark.
Netrvám na tom, čo som uvedol.
I do insist on everything that I have written in my witness statement.
Okay. But that one you have written as well. But this I have written for you. 1,550,000. It's not me that have written it. You've written it. You wrote in it. You acknowledge receipt of 1,550,000 Deutsche Mark.
Tento dokument som nepísal ja.
I'm not the author of this document.
Who is the author of this document?
To ja neviem.
I do not know.
It has your signature, your name on it.
Podpis vyzerá...
Signature looks like mine, but I cannot fully confirm that it is also authentically my signature. It is a copy, and what I can only confirm would be an original if I would see it.
On it, you will agree with me, under your signature. And I have the signature of your witness statement. Sir, I have the signature of your witness statement, and I have the Slovak original with your name on it. And it looks very consistent. I mean, it looks like you have kept consistently that signature throughout the years, no?
Vyzerá.
Again, I'm not familiar with this. I haven't received this. Probably I haven't even signed it. That signature does look like mine. However, I cannot confirm to 100% it is my signature.
It's the first time you see this document?
Nie, nevidím ho.
No, I'm not seeing it for the first time. I believe I have already commented on it before.
But it's just, so you don't know whether you received 1,550,000 Deutsche Mark, moreover on behalf of yourself and 3 other people. Is that your testimony? I mean, you rehash things about
Yes.
100,000 euros of invoice that caused bankruptcy, and then you don't remember 1,550,000 Deutsche Mark.
Opakujem.
Again, I'd like to state that I have not taken this amount. I have not received this amount. Never.
Then it's a forged document, correct? If you have not received it, but you say you have not received it, but then you say, I'm not sure whether it's my signature. That's what it bothers me, and I have to engage a little bit with you further. I would understand if you say, I haven't received that money, and I'm sure it's not my signature. But to say, I have not received that money, then I'm not sure it's my signature. That means you're not excluding it could be your signature, and if you're not excluding it would be your signature, it means you would have cashed that amount. You're a wheeler dealer, aren't you?
Opakujem ešte.
Again, allow me to state that I have never received in cash an amount in this volume from Mr. Robel. Never.
In check, in bonds, in gold, in talc, did you receive 1,550,000 Deutsche Mark at the time? From anyone, let's say. How about that year?
Nie.
No.
Okay. So I ask again, are you sure or not whether that is your signature on that letter?
Vyzerá to...
It looks like my signature. I cannot confirm because this is not an original that I am seeing in front of me.
Sir, do you understand how grotesque the situation is? Because if you're sure that you didn't receive 1,550,000 Deutsche Mark, you could only be 100% sure that it is not your signature. That's the problem.
Poprosím ještě raz.
Can you repeat, please?
Alebo...
I say you say you're sure that you didn't receive 1,550,000 Deutschmark. Then how can you have doubts as to whether or not this is your signature as contained in that letter, where receipt of 1,550,000 Deutschmark is mentioned?
Ještě raz.
Once again, and I hope for the last time, this amount was never given to me by Mr. Robol in cash, as he states in his witness statement. This document, I dare to say, may be a forged document.
Did you discuss this letter with the other 3 persons that are named? The 2 other, or
Tie osoby ani
2 others, thank you. I gave you my copy.
Tie osoby ani nepoznám.
I don't know these people. I don't know who that is.
But frankly, what I'm astonished. You know why? Because we submitted that with our statement of defense, which is more than 18 months. A statement of claim, the memorial. And you have not bothered to inquire whether it's a forgery or not. And you provide a first, second witness statement talking about bills of ridiculous amount. You took that money, sir, and you didn't declare it to anyone. That is the truth, correct?
Nie, pravda.
No, that is not the truth.
Mr. Garay, I think Tribunal understood the point.
I will move on. Did you meet, do you know when the rights of Roseman were revoked?
Práva rozmenu.
In my honest opinion, the rights of Rosmin were never taken away from them. They have lost them by their lack of activity, because they simply failed to start the mining activity in the prescribed period.
You reformulate. I don't want to engage in a legal battle with you, Mr. Čorej, but only on factual questions. So I will reformulate so that you feel comfortable. Prior to January 3, 2005, how many times did you meet with Mr. Dusan Cheller from the mining office to discuss this talc deposit?
Asi dvakrát.
Perhaps twice.
Is that regular, normal, lawful to meet with a state representative in relation to a talc deposit where there has been a authorization granted or a right granted to another contractor? Is that in compliance with the law?
Je to absolútne.
I believe it is fully legal.
Sure, or is that an opinion? Is that a wish? What is that?
Som si istý.
I'm certain.
Did you, how many times did you meet with Mr. Kukelchik prior to January 3, 2005?
Asi 100krát.
About 100 times.
Yeah,
To discuss the talc deposit. In November, let's be more specific. In November, December of 2004, 2 months before.
Ani raz.
Not a single time.
Okay, how about in January 2005?
Nespomínam si.
I do not recall, perhaps not a single time. There was no reason for that.
And Mr. Čeler, who you met, I understand, in November, December, correct, 2004. Is that correct? That you met her in November, December 2004?
Again, please rephrase the question. What's the point?
Mr. Dusan Čeler. It's not a point, it's a question. How many times did you meet Mr. Dusan Čeler in the months of November, December 2004?
I have said perhaps twice.
Where?
Well, one meeting was in Košice, if I recall, and the second meeting in Bratislava.
Who was with Mr. Čeler?
When?
Well, the two times you met him.
Ktorý termín myslíte?
The two times you met him.
Myslím, že bol...
Well, I believe he was always accompanied by Mr. Keller.
Mr. Keller. Anybody else from the district mining office or the main mining office?
To určite nie.
I'm certain that was not the case.
Mr. Čeler was alone, representing either the district mining office or the main mining office.
Pán Čelar nezastup...
Mr. Čelar was not on behalf of nor the MMO or the district mining office. He was there as a private individual.
He held a function at the time.
To nelegitimuje...
Well, that doesn't, the fact that he was an official doesn't bar him from meeting privately other people.
This I can understand. Oh, thank God that as being a officer, public servant, a civil servant, doesn't bar him to meet others. But to discuss this talc project, he was discussing it at the time with you in his personal capacity, you mean?
According to my opinion, he was there on his own behalf.
How can he be on his personal capacity to discuss a official talc deposit with a potential candidate to the succession of Roseman?
Because nothing bars him from such meetings. There is no legal document or no law which would ban him from meeting and talking about these things. He's a mining engineer. What am I supposed to talk with him about? Medicine?
Again, in the two times in his offices, in a cafe, what was your testimony on that? You said you met him twice, November, December. At what precise location? You mentioned the cities, but not whether it was in the office, in the restaurant, the social gathering.
You mean Mr. Čelar?
Subject, you know who I mean.
Twice in Košice, I believe.
In a restaurant, in a discotheque.
Well, I can give you a precise answer. This was in restaurant Lekna in Košice.
Okay. It was the second time or the first time? It's not easy, huh?
Perhaps the first time.
Okay, the second time?
This was again a meeting in Košice, I believe.
You're buying more time to think of the location, huh? I know it's not easy when you're making up, huh? You're making it up, aren't you?
Yeah.
Once again. When I entered this room, I've read a statement claiming that I will testify according to truth. This is what I'm saying. This is the truth, the way how I've experienced it, the way how I've lived it. That's what I'm giving you. Nothing else, nothing more.
You met him at what?
Opakujem, v Košiciach. V Košiciach.
Again, this was in Košice. Once again, Košice.
First time you had a meal, the second time probably if he invited you, you probably invited him to a restaurant again, or this time to your house, to... If you don't remember, you can get it out of the way, say I don't remember.
Nie, to si presne spomínam.
I recall the second meeting was in the House of Technology in Košice.
The House of Technology? What is that, a ministry?
Nie. Minister.
It's not a ministry. It is a building dedicated to technology. The interpreters add it is a building in Košice. It is not a state official building. It is called Dom Techniky. It's just a common term for it.
Discuss at that meeting. At those two meetings.
Prvé stretnutie v podstate inicioval.
The first meeting was initiated by Mr. Keller. Before mentioned, Mr. Keller. Mr. Cellar took part in this meeting. Myself and Mr. Benhoda. This was a meeting organized on 11th of December 2004 in Košice in the restaurant Letna.
Do you think you answered my question sincerely? Is there a translation problem? I said, what's the content of the discussion? You repeat now you met at a restaurant at the initiative of Mr. Keller. What was the content? You didn't meet to just eat food, did you?
Nie, nešlo o jedlo.
No, this was not only about food. Mr. Keller came and with a certain proposal to me, because he knew me from the past. We have met before at the deposit during the Rosmins period, and he knew me as a person who worked there for many years and considered me an expert in the given field. And that's why he wanted to propose me, which he did propose me, a certain cooperation should the situation occur that there will be a tender called for a reassignment of the mining facility or mining area to another entity.
Chairman, I think there was a translation issue. It says Mr. Keller came with a second proposal. I'm told in Slovak it was a certain proposal.
Thank you. But for Mr. Keller to come with a proposal, there must have been a prospect of a tender. So what made Mr. Keller believe that there was a prospect at that point in time for the deposit rights to be retendered?
Ako som spomínal,
As I mentioned already, Mr. Keller had been observing the project for many years. And I suppose he was, quite certainly, he was in contact with Mr. Robel at that time when, at the location since 2001 to 2004, there was no work conducted there. Let me point out, no work related to opening the deposit and drilling work. And since he was familiar with the Slovak circumstances, knowing that an amendment was adopted, I think it was in 2002, about organization which has mining area assigned to it is obliged to commence drilling within a certain deadline. Based on this act, in December, it was almost clear that Rosmin is not going to commence drilling. I call it excavation. Professionally, dobývanie is that's the key word from my experience. So he expected, once this situation shall occur, we shall submit a proposal, whether I be willing to enter in cooperation of certain kind with him once this situation shall occur.
Understood. Let us pause there. Mr. Mondo was interested in his personal capacity or on behalf of Mondo to do this? On behalf of Mondo, correct?
Vystupoval ako zástup.
He acted as a representative of Mondo Minerals, but it's difficult to say now whether it was his personal interest or whether it was interest of Mondo Minerals as a parent company. But I have rather viewed this as his personal interest.
In his personal interest, was he also emotional about talc or sensitive towards talc, or had he a financial perspective based on how you perceived it at the time? It's a valuable mine, isn't it? It's a lot of money that could be generated out of this.
You know, we could talk for hours about this topic. First of all, it's not as valuable as a mine because there were certain stages of geological survey conducted, and mainly on the surface bores were drilled. And based on these surface drillings, calculations was made with regard to the size of the deposits. Z1, Z2, and Z3, there are maybe 85,000 kilotons and 160,000 kilotons of the non-balanced deposits. And I did claim, and I continue to claim, that these are very distorted views upon the deposit, because the drills were done within a certain network or a grid based on which no one can have a perfect overview what's the size and yield of that deposit. So that's why I continued.
My fault entirely, because I threw a question at you that was so vague, and I understand why you want to go into details, especially that you're passionate probably about this. But let me put it this way. It was sufficiently financially appealable to both you and Mr. Keller in his personal capacity on behalf of Mondo that it warranted Mr. Keller coming in and you or him sitting up with a representative of the mining district mining office, a meeting to consider the prospects of a retender, correct? I think you can agree on this.
I disagree with that, because that is not truth. Whether the motivation of Mr. Keller was a financial gain, I cannot answer that, because I did not see inside his soul. I can only say on my own behalf, I have never seen a personal financial gain in this. I have seen a certain realization, implementation, or continuation of my work which had begun before. Nothing more and nothing less. The financial benefit, the financial benefit can have someone who invests his own money, a miner having return on his investment in time. They may speak of whether or not the deposit was or was not beneficial or profitable. But whether it was a bona fide deposit, to say now at this stage is very premature.
Sir, then can you tell us why Mr. Keller was present? Because your testimony is that Mr. Keller came to submit a proposal to you. How does that explain Mr. Keller's involvement at the first meeting?
I suppose that due to that reason that Mr. Čelar was, I'm not sure at that time whether he was already the Košice district mining office head. And they've known each other from the past, or I guess he just approached him and he come. And I have to say that Mr. Čelar does have at least very little information about this deposit. I would say almost zero.
Mr. Čelar's input at that meeting? At the restaurant. The first time was at the restaurant, correct? So what was the input of Mr. Čelar?
V podstate nejako.
Basically none.
He was sitting there.
V podstate áno.
Basically yes, he would just sit there. He doesn't speak German. in fact, so he would have nothing to discuss. If he said something, I'd just try to help him translate it.
What was he here then for? I mean, it doesn't make sense, does it? Sir, I put to you...
To je jeho osobné rozhodnutie.
It's his personal decision. He was there as a representative of mining offers in the region. Keller knew him from the past, so he came. It was a courtesy call.
Sir, may I put to you that
Je
this
to
was...
úplne legitimné.
It's quite legitimate.
Sir, may I put to you that this is a valuable mine. You know it. You are a sour former shareholder and contractor. And you set that meeting with Mr. Keller to set the basis to have Roseman's rights revoked, a phony tender organized for your phony company that you set up in the name of your wife, who is an accountant, with a company that does brokerage with no financing backing, to then be allocated the tender. Isn't that truth? That's the case I'm putting to you, that all this was set up thanks to you and the complicity of members of the government.
To je váš názor, ja vám ho neberiem.
That is your opinion, and I'm not objecting against that, because you put 10 fragments into a single sentence. I'm not sure it even makes sense to try and answer it, but I think further development will show that we shall get to the individual partial topics.
Mr. Cheller, was he reporting of what was going on to Mr. Baffy?
To je otázka na pána Čelára.
It's a question to Mr. Chelar, so excuse me, I have no professional relation with Mr. Chelar. He's the head of the mining office. What relations were there between Mr. Baffy, Chelar and others is not a question to me.
About the Minister of Economy, you wrote to the Minister of Economy. There was a meeting set with the Minister of Economy, I understand as well, right?
Áno, to
Yes, that meeting took place. Correctly, it did take place. It was a courtesy letter from my side, whether or not the Minister of Economy would accept such meeting to take place.
And it took place when?
Stretnutie sa
The meeting took place, if I remember correctly, on 12 December in Košice.
Cheller was present as well.
Yes, he was.
Meetings with Mr. Cheller, one at the restaurant, one with the Ministry of Economy, you and Mr. Keller, and a third at the House of Technology during that period of November, December. That makes 3, not 2.
ešte raz.
Once again, at the time we referred to, I have met him twice in December, twice in Košice. So 11 in the evening and 12 in the morning.
Mám na mysli,
What I have in mind is the period of December 2004.
Okay, so you met him twice in November and once in December? Is that your testimony?
dvakrát som sa stretol
I've met him twice in December. Repeat again. Once 11 December and second time 12 December. Once together with Keller, Bernardo and myself, and now 12 with Mr. Rusko in the House of Technology.
Okay, so the meeting with the minister took place at the House of Technology. Is that how I should
áno,
understand?
áno.
Yes, exactly.
And the minister was here on his personal capacity as well?
Áno, bol tam osobne.
He was there personally.
He was personally, what do you mean physically? Of course he was there physically, personally, but was he as a minister or was he as a layman?
Určite, že tam bol
Certainly he was there as the Minister of Economy.
zodpovedný.
At that time responsible for the sector of mining as well. But it was not motivated by his participation was not only motivated by this meeting alone, because they've had some kind of other meetings there at that time, which coincided in time-wise, so he was able to schedule and thus be able to meet us on that day, which has happened to have worked out time-wise on that day.
Well, maybe I listen too carefully to you, what you say, or I just don't understand. So the minister was here in his capacity as minister. Then Mr. Čeler was there in his personal capacity, or was he then on his also on his professional capacity? Because you mentioned personal capacity, Mr.
Bavíme sa o dvoch rôznych veciach.
We are discussing two different things. I'm talking about the 11 December meeting. It was Mr. Čelar as private person together with Mr. Keller. Now, on 12 December, he was likely there as a representative of the mine administration, the district mining office, because he was there with minister, under whose ministry the mining sector belongs. I suppose Mr. Čelar was there in his official capacity.
But the first time he was there personally. The first time, December 11th. In November, the first
To bolo
time.
večer, to bola...
It was in the evening. It was a regular working meeting, and it was informal. There was not binding. There was no record or minutes made of this meeting, and we were discussing things. What if? And there was no conclusions reached during that meeting. There was a model proposed, and there was a model proposed between Mr. Keller and not even myself proposing it to Mr. Keller. It was Mr. Keller proposing me a model for cooperation.
Okay. Did you meet Mr. Baffy in January 2005 or in December 2004?
Myslím si, že...
I think not, because even though my organization, because there are district mining officers and each organization has jurisdiction into appropriate mining office, but at that time I don't think I had any contact with them, and I would not be meeting with him during that period, even though I say that there could have been a working meeting, but I think rather not.
With Mr. Baffy?
S pánom Buffym, áno.
Yes, with Mr. Buffy.
But I apologize. I do not know. I cannot understand how you cannot remember, because that's a key period just before the revocation of Rosamund rights, whether or not you met Mr. Baffy. Because Mr. Baffy is the signatory of the revocation letter. He was following the process. Can you make an effort to come with a clear position? Did you or not meet Mr. Baffy in December of 2004?
Jasne hovorím.
I say clearly, I have not met with Mr. Buffy in December 2004.
November 2004.
Ani v novembri.
Nor in November 2004.
In January 2004. 5.
Ani v januári 2005.
Nor in January 2005.
Okay. When did you learn of the intention of the district mining office to put the deposit in tender?
Bolo to uverejnené v...
It was published in the journal for public tenders. That's where I read it.
Sir, you've been meeting, you've been soliciting, you've been triggering the process. There is your letter of November 24th, 2004. There are meetings at restaurants, at the House of Technology, in relation to the TALC project. And you want me to believe that you found out about the tender only when it was published in December 30th. That's your testimony.
I can say with certainty that I knew about the act being applicable, but whether the mining office shall make such step, they did. Don't ask me to tell you that I would be aware of mining office making such a step. I did not have knowledge of that.
What about Mr. Roznik? You seem to value him. I saw in few paragraphs, I can find them if you want me to direct you to these paragraphs, that you value him as a person and as a professional. Is that a correct understanding?
Musím vás poupraviť.
I have to correct you. I used to appreciate Mr. Rozložník very much. We've known each other for many years as professionals from sporting activities. We would meet frequently. I nearly had a father and son relation with him until situation had occurred where he disappointed me, and unfortunately now with hindsight I have to say that that person has disappointed me gravely.
Okay. Well, that's at a personal level. How about professionally? Do you value his judgment? Do you recognize that he's an industry specialist in the Slovak Republic? A mining industry specialist?
Nie.
No. Because he's no miner originally, it's difficult for me to judge the work of a geologist. I only knew him as such on one, maybe 2 or 3 projects, but it's difficult for me to judge his professional know-how in the area of geology because I have studied deep mine, mineral and non-mineral mining as a profession, so it's a fairly different profession, so I would not presume to judge his professional expertise and know-how as a geologist.
Okay, he came and testified that the term dobinvanie, as set out in the 2002 amendment, does not mean extraction, but as he understood it at the time, to mean mining works, to start the opening of the mine. Now,
Mr. Chairman, we object to that characterization of his testimony, and it should not be represented to our witness that that was the testimony of Mr. Rozložník.
Could you yourself suggest what you understood from Mr. Rozložník on the definition of dobivanie?
Well, do you mean when he was answering my questions or when he was answering Mr. Garavi's question?
Well, if they are both, and if they are different, we're interested in both.
I can move on because there is no material point. Well, just an introductory point. I'll get to the Supreme Court decision. Have you read the Supreme Court decision? Because you seem to be very much following this, especially after what happened, because you became the beneficiary of all this. So did you read the 2011 decision of the Supreme Court? I can walk you through it. It basically said that it's only in 2007 that was provided an explanation as to what the term dobinvanie meant. Do you recall reading that decision?
To je to prvé či druhé?
Is that the first one or the second one?
So you follow. Good. There are 3 decisions. It's the one of 2011. My colleague will show you that decision. It was the only one that discussed this point. Should be tab 39, I think, but I don't want to insist too much on that. I'm just curious to see whether he has read it. And it's in page 25 of tab 39 in the English version, C36. It should be underlined in the Slovak version. Page 25. The Court of Appeals points out that the statutory definition of the term mining as of activity of the organization in the mining area through which the acquisition of mineral from the deposit in mining way occurs was introduced in the Mining Act only when amended in reference to a law of 2007, effective since June 2007. That is why a restrictive explanation of the term start of mining of the excluded deposit, which was adopted by the administrative bodies in December 2004, is not correct without an appropriate reasoning. So do you recall having read that decision? Well, you didn't care because you got the mine anyway.
Ono, že som ho čítal, ale už si jeho obsah nepamätám.
I might have read it, but I do no longer remember its content.
Okay, fine. Now, let's move on. Assume with me that Roseman's right was rightly revoked, and I think you would have no problem in proceeding based on that assumption. There was a tender. Let's forget about your meetings in December and November, and the tender, let's assume it was regular. How do you explain that that company that you set up, economic agency with your wife, managed to win that tender? How do you explain that?
To je, myslím, že otázka na výberovú komisiu.
It's a question to the selection commission, which had made a decision about that.
See, I work on the presumption that all this is a phony and is a big joke, in the meaning that the whole practice is corrupt. Because it doesn't make sense for the government to get rid of a contractor that is not serious and then to take a company managed by created by an accountant whose husband also claims bankruptcy for 100,000 euros. So I'm asking you, what do you think, why you, it's not lottery, you can understand why you won a lottery, you took a number, and your number fell. But this is a tender. There's a 2002 amendment.
No one revoked Rosmin his mining license. They did it themselves. Everybody which was involved knew very well about this, including Mr. Rozložník. He did not speak to one expert, but to many. And unless they will commence dobývanie, excavation, they will be revoked their license and they will be transferred to another organization, which did occur, in fact, due to objective reasons, because Rosmin did not excavate anything. That is why the tender was called for transferring this license to another organization. So tender was called. It's difficult for me to doubt something which is legally established in Slovakia by law, because it was a legally made procedure, fully accepted, fully published in a journal. I have read it, and exactly to the last point I have met the conditions of the brief in order to be able to participate in that tender. So I suppose, and I think even, that my project was assessed as the best one due to the reason also that perhaps I was the best familiar with the issue of the deposit, because I have been involved in it professionally for the 24 years previously.
What financial support? First, let me step back. Why your wife? Why send your wife on the battlefield? Why economic agency? Your wife is an accountant. You put her as a bidder. Why not yourself?
Takto.
Okay, well, my wife is not an accountant. She's an engineering economy, but she's very well familiar with accounting as well, and appropriate laws relating to accounting. With regard to my decision of doing it not through, it's a misleading information that I have done it through my wife. I only have done it through a company which was in the ownership of my wife, having met all particulars in order to be able to participate in a tender. It was my honest decision, after having had the experience previously with Keller, with Robal, to be able to decide freely like this and to do it right. Proof to having done it right was the successful outcome of the tender. And in my opinion, based on the bid I have submitted, works were conducted, and today the deposit is opened and there is excavation underway. That is the most important part.
You just said, I thought it was better to do it in the name of my wife, and a company owned by my wife. And I'm just trying to understand, when you took that decision to put up that company in the name of your wife, and why did you proceed this way? So first question, when did you decide to create economic agency?
economy agency was not established before. It has been a long-standing company by then. So I have to correct you in that. There was only one thing which occurred. Every company wanting to participate had to hold a mining license, permit. Authorization, forgive me. So that is the reason the economic agency had requested, based on my professional aptitude, to have a license for performing mining work. So that is why I legitimately was able to participate in this tender.
I understand, but why your wife, a company under the name of your wife? This I don't understand. This is what I want you to help me with.
There were several options available, as I already mentioned. With Keller all of a sudden, at the last moment, had refused cooperation. He said he will go participate, or he will bid by himself. I could continue in the tender with my former company. The shareholders were no longer interested. I could have found a new company. I was approached by Belmont that they would be very happy if I were to join them in the tender, regardless of through which company, but if I were to submit my project, to get in touch with them and we will go into it together. So after having had the previous experience and after having made up my mind, I have decided that this will be for me the most optimum and the best solution. And I think I have not done it badly.
I won't insist, but my question was not why you didn't go with the others, why you created a company and put it on the name of your wife and proceeded this way. But I'll move on. The question now I have for you is that...
I would just object to that characterization. He did not say he created it and put it in the name of his wife.
The question I have for you is that what was the financial plan? I mean, what was the financial backing? You say you won because you had the best proposal, technical proposal. But financially speaking, what was the backup? What guarantee did you give to the government that you would yourself meaning the economic agency, proceed with the project?
Well, first of all, the decision was not made by the government, but a selection committee, which was appointed by the district mining office, which was responsible for this specific area, for this location. The fact that the parameters for the selection procedure are defined by law, also the fact that the committee assessed the bids as they have assessed them, I couldn't have any influence on that, nor have I tried to influence it. This was a legitimate decision of the committee.
That was not my question. Every time I ask a question to a witness or respondent, they said there was law was applied. Law. My question is, what was the financial proposal? The letter you sent on 24th of November 2004, for example, the one that we had read, R0247, mentioned that the above-mentioned companies, you were talking about Mondo, expressed an interest in investing 50 million. And the goal, I understand, of the 2002 amendment was precisely not to allow companies that didn't have the means to secure the project. That's why I'm asking you. It's a very direct question, sir. Did you have that money sitting in the account? Or do you have a lot of money and you put that as a guarantee? What did you say?
Well, this is clearly defined in the project. A project has a part which talks about a financial backing. We had the credit pledge of a bank. I think this was enough for the selection committee. I had also backup plans in my head because I had several investors who were approaching me.
I was not talking about your head. Let's stop there. You said you had a pledge from the bank. What was the content of that document? Who issued it? What were the terms of it?
Myslím, že to vydala Tatra banka.
I think it was issued by Tatra Banka branch office in Košice.
Did it say? What were the terms of the letter?
To si už nespomínam.
I cannot recall anymore.
But how could you not remember? You win a project, takes tens of millions of dollars. You commit to it. You talk to a bank institution. It issues a letter. You submit that. And you say you don't remember. And you come up with these bills again, dating from a long time ago, of petty cash. How come you not remember the terms of the letter? Please make an effort.
Ešte raz opakujem.
Once again, it was a credit pledge from the bank that if we succeed in the selection procedure, they will finance the project.
Well, project, or they will sit down with you to discuss possible financing of the project. They're two different things.
Takto. To nie je...
You are correct, it's not the same. I don't know how much you are familiar with my project, but my project included all the required parameters as they are required from a project, including a business plan, covered with the financial backing, who will do what and when. On the basis of this project, I approached the bank, and on the basis of this business plan, I have received a promise from the bank that, yes, that according to their opinion, this project can be implemented. I don't think that they will issue a pledge like that just, on the basis of nothing.
Still have it? Would you agree to show it to us by curiosity? Would like to see it? Do you have an objection? I mean, of course, your lawyer would say whether it's appropriate or not to provide it, but do you have a copy of it?
Toto určite nemám, pretože...
Well, I certainly don't.
What's that? What is this? Why don't you? Well, how can you be sure you don't have it?
Som si určite...
Well, I'm quite certain I don't have it, because the bank issued it to me. The document is one original. This original is a piece of the project bid, and I suppose the bank might have it in their archive.
You do a photocopy of it.
No. Nie.
No.
Okay, let us move, and I think we should have 5 more minutes, not more. I think. Sir, what was your intention when you submitted the bid? Was it your intention for the economic agency directly or through you, not talking about third parties, economic agency directly or through you, Mr. Čorej, implement the project, or was it for you to get it and then sell it to somebody or bring in somebody to do it? I'm not talking about what you did, I'm talking about your intention and what you represented. What did you represent and what did you intend?
My main motive, single motive, was following. To make sure that I will successfully pull this project. I was unfortunate enough that during the 90s, all the way up to 2004, I was meeting investors who were behind companies such as Belmont and EuroGas, and I was disappointed that this significant project in terms of employment, in terms of mining activities for the district of Rožňava, that this project has failed. For that reason, when in 2004 I've started to consider on the input or on the incentive from Mr. Keller on taking another angle at this project, I was again disappointed also by Mr. Keller. And just before the selection procedure, when Mr. Keller cancelled all the agreements that we had, I took the decision on my own that I will enter this tender procedure on my own, and I will prove to everyone that I can pull this project through. The result is that I have succeeded. The project that I have elaborated was the basis for the final construction, and it's perfectly functional. I have nothing to be ashamed of. I'm very glad that this deposit is finally serving its purpose.
Maybe that's the case, but you still have not answered my question. My question was a simple one. When you applied, when you submitted your application, did you intend for the economic agency to carry out the project directly itself without any financial support, or through you, Mr. Čorej, without any third-party investors, or did you intend to take that project once you won, sell it, or bring in another partner, and for that other partner to do all the financing and carry it out?
Určite nie, pretože
Definitely no, because in my business plan, the idea is clearly outlined. What was my idea on the implementation of this project? Already before, in the history and also in case of this project, my intention was to employ my employees, those people who had to be laid off in the year 2000. So I was employing them at other jobs, other contracts, and therefore I was very glad that in 2005 the selection procedure concluded as it did. And I had a very clear business plan on how to make the best use of my employees for these works. Later, when I've merged with another applicant, Mr. Engel, who approached me with a proposal to cooperate, we've finally opened this this talk deposit, and the main part of openings and also the approach, the initial approach, was done by my company, and that's why I'm happy that I found job for my employees who could succeed in case of opening this talk deposit. And now they are working for another company, and at least they have partially covered their fees and their employment for the current day. This was my leitmotif.
I understand that your testimony is that once you obtain the project, you engage into negotiations with other companies, including with Mr. Robal, for Mr. Robal to possibly step in to provide financial support. Is that correct?
je to absolútne
This is quite misleading. Mr. Robal, not specifically, but Mr. Aďagoš, have approached me during the process of preparing the project with a proposal to write a project, and if I would be successful, to join them or to merge with them, and we would create a joint group and under certain conditions, and we would continue to work on this project. But I understood quite quickly that this is just a sidestep from Mr. Robal's side, because when I've asked him how will he guarantee the financial backing of this project, he said, just behind the corner there is a bank which will finance it. It was quite clear to me that he had no idea, or at least from his behavior it was quite clear, that this cooperation with me is serious. That was the reason for me to refuse his proposal. This was a proposal by means of a company that I was not familiar with, and he wanted me to transfer this mining area or excavation area to this company I was not familiar with. So I'm very glad I've merged with Mr. Engel, and we've pulled through this project to a successful end.
You did meet Mr. Robal after the selection process, once you were awarded the tender, to discuss his proposal, correct? You listened to him. You met?
nie. Rozprával
No, I was talking to Mr. Royce.
človek, ktorý prišiel za mnou a
It was a man who approached me, and he offered me a cooperation on this project.
Turn to paragraph.
Just before we do, we have a translation correction. I think it's the sentences, or at least from his behavior, it was quite clear that his cooperation with me is serious. Is that correct?
It is not serious, was the testimony.
Could you turn to paragraph 40 and 41 of your second witness statement? In there, at paragraph 40, you say, after the selection process, I was contacted by Mr. Proust as the authorized person of the group or EuroGas. I knew Mr. Proust because he often represented Mr. Robal at meetings, and he also acted on behalf of the company EuroGas. Then 41, at the meeting in Vienna, Mr. Proust submitted to me an offer for cooperation, this time with the company TransUnited Corporation, which had its seats in Liechtenstein, to ensure financing of the works at the deposit. When leaving the meeting, I also met Mr. Robal. During a short discussion, he told me that it is no problem to ensure money for financing the project. I was willing to listen to this proposal. Then you say 42, after exchanges of drafts of the cooperation agreement, however, I realized that Mr. Robal could not demonstrate a commit to financial support of the project, and there is actually no money for the works at the deposit. I mean, what I don't understand is that you don't believe in EuroGas, in Mr. Robal. You say that he's the cause of your misfortunes in 2001. Then you write to the government, you say these guys are losers. They don't have the money. You have project to move this forward. There is the 2002 amendment. You get the project. Then you sit down with Mr. Robal to discuss project financing to move forward. I mean, what sense does that make?
I think you've talked about initially about the year 2001, not 2004. This was the beginning of our problems with Mr. Robal. Well, it was an offer from their side. I thought that Mr. Robal is now a more serious trading partner. However, when we've started to discuss particulars of this project, I again saw misleading, and it would bring me into a dead end. And I did not want to relive the situation from 2001, when I was in a very unfortunate situation, given the collapse of the project. And I was very sorry for that, because this project has a certain perspective.
But you did say that you exchanged drafts of cooperation, paragraph 42, and I wanted to draw your attention to one of the drafts that you mentioned, which is R0250 in the pochette you have. And you mentioned in your testimony that you didn't think all this was a serious proposal. And I want to cover the content of it with you. There's a draft that says TransUnited Cooperation with Economy Agency. The company TC, which is TransUnited, moves forward. Is interested in cooperation. Item 3, it says it provides funds to open the deposit, 300 million, of which 50 million will go to EA, which is Economic Agency. And then at 6, it says the company EA, which is yours, will be prepared after completion of the opening works to transfer its ownership interest to the company in the amount of 100%. So what I understand is that TransUnited here is proposing with you in this draft for it to finance the project with a 50 million upon signature of this agreement, then proceed, and at the end it will get the 100%. So what would you get out of this? I mean, what was, is the 50 million, you were going to pocket that 50 million and keep it? May I suggest that? What's the rationale of this agreement? I'm trying.
Totally failed to understand me.
What's the rationale of this agreement? You said
Well, if you have read this agreement well, I do believe that there is a clear bottom line, that my intention was following to finally open the deposit and to make sure that we will finally start the excavation, nothing less, nothing more. I wanted to make sure that I, as someone who is very familiar with this issue, who has spent many years on this site, who has managed various openings on various borehole drills, what I wanted was to have the authorship oversight over this project, and also to be responsible for one thing, namely to make sure that the funding will be available, and once the deposit would be open, I was willing to transfer the ownership to this company, Trans whatever, but let's call it Mr. Robol. This was my only and single wish. It took a different shape at the end. I'm no longer working on this deposit anymore, so the opening works are completed. The raw material is excavated. I'm satisfied.
We heard that, but I'm there. I'm there now. When did you win the tender? Tender result, when was it? It was April 2005, correct?
No.
I believe so.
Okay, so immediately when you win, who you start negotiating with
Ináč musím
is
povedať.
with Mr. Robol.
Correction. There is a mistake. This is not the 22nd of April 2005. This was supposed to be 22nd of May 2005. There was a mistake in the mistakes. This was on the 22nd of May, not on the 22nd of April.
Well, I have the Slovak version. It says 22nd of April. And in your testimony, it refers to also, this document doesn't have a date, but anyways, it doesn't matter, April, May. You win the tender, there is this amendment of the law that requires you to move forward the project. You say that that matches your heart. Then you just kicked out, rightly, let's say, Roseman, that is owned directly, let's say, claimed to be owned by Mr. Robol at the time or his group of companies. And then you immediately not only meet with him to listen, but you engage, exchanging drafts. So I find that extraordinary. I think that it is untenable that this whole story that you put forward makes sense. But I'd like to move on and understand the rationale behind this. Under the draft, what were you going to get? What was Economy Agency going to get? The way I read it, it was you're going to get 50 million, you're going to pocket it, the other one was going to finance it, open it, and then you would...
Well, this is a totally misleading interpretation, and you have absolutely failed to understand the content of this document. I would like to again repeat that I have bound myself when I've entered this tendering procedure that if I succeed, I've promised to myself that I will pull through this project. This, in my term, or my understanding, was to make accessible this deposit, open up this deposit. And for me, that doesn't matter whether it would be excavated over 50 years, 100 years, whatever. And one other comment. Rosmin did not lay me off. I was not made redundant. I never was an employee of Rosmin.
What I was trying to understand, I'll ask you one more time, is what was your consideration? What are you going to get financially? I don't want emotional consideration. Financially, what were you going to get according to the draft that we just read?
Well, I suppose I was paid for a certain work. I was supposed to perform expert oversight. This is what I was supposed to receive my remuneration for. For me, this was a lot.
We're going to get the project, immediately give it to the hand of somebody else without any financial contribution, and you were going to go get a salary from that company? What is your present deal? Let's move on. What's your present deal? After that, you gave it to another company, right? So what was your deal with that company?
I never gave anything to anyone. In the process, we had 7 companies involved. The company which was second in the overall order, I think this was Východoslovenské kameňolomy a štrkopiesky, the owner of this company approached me after the tendering procedure whether I wouldn't be interested in working together on opening this deposit. And he guaranteed financial backing of this project.
Okay, but what's exactly your deal with VI? What's your deal? What's the exact term? What is your contribution? What are you receiving financially?
Došlo k zlúčeniu.
There was a merger of these companies, and eventually only Värska Mining ended up as the final company because they had a gypsum deposit and one other deposit. I've agreed with these transfers that they had within the company, but my condition was that in any case I have to perform the authorship oversight supervision over the project.
Etc. I'm asking you, what did you get? You merged. How much did you get in cash upon signature of the agreement? How much did you get? Or did your wife get? How much did you get directly or indirectly?
Nič.
Nothing.
Nothing.
Nič.
Nothing. So what was the consideration? What was your financial reward for that?
Mne išlo o banickú česť.
In my case, this was the honor of a miner. The tradition, my father was a mining engineer. My brother is a mining engineer.
I don't care about...
Mňa osobný profit...
Don't interrupt, please, Mr. Gary.
Personal profit on this project was not my motivation, nor is it a motivation today. My intention was a certain personal ambition, a personal promise, which I've carried out, and this cleans me. And I have to say one thing, that this makes me very proud, that this project is implemented as I have projected it. Up to 99%, this is my project. I haven't failed in a single thing, nor projecting the initial shaft, nor projecting the distance. I have failed in 7%. We are talking about 4,160 meters. I haven't failed in projecting the main directions, the main angles. So all my projects, everything was done. 4,000 meters were drilled in 12 months. In 24 months, sorry, apologies.
A few minutes maximum. Okay. Sir.
Sorry, first, I think there's a correction to be made in the transcripts. I suppose it's I have not failed, or yes? Okay. Now, not too long, Mr. Garavi. We can go on tomorrow.
No, I really would like to finish.
Yes, well. But quickly then.
Yes, but it depends on the answers. You appreciate that, because I don't feel...
It depends on both the questions and the answers.
But yes, if I get a answer to my question, which is very simple, what you got in return. If it's zero, I'm fine and I'll move on. But is that what you say? Is your testimony is that you received zero from the 100% merger? I want to make that clear. Is that my understanding correct? You transferred the 100% share and you got zero direct and indirect financial benefit.
Allow me to restate and reformulate. No, my personal miner's honor is more to me than any financial profit from such activity.
Means I don't want to answer.
No, that's his answer.
But what do I understand from the answer? Okay.
That's his answer.
Okay.
Believe I have answered your question. I haven't looked for any personal profit.
Okay.
This is valid today and it was valid before.
Okay, you say at paragraph 61, and I will end with that, you say the works were completed sometime in 2009, and in this period, I presume in April, the first ton of talc was extracted. So, within this time, your definition of extraction, dobinvaje, when did you achieve that? Do I understand that it should mean in April 2009?
If it has a date, I believe that was the situation. I don't think I have inserted this in my witness statement. I don't think I have specifically stated the date when the first ton was excavated. I haven't specifically mentioned a date when the first stun was excavated in my witness statement. I believe this might have been in April 2009.
Say, sir, and so that I understand, what's the start date for the running of the 3-year period? We agree on an approximate date, and I give you that it's not a scientific date. April 2009, extraction started, okay? When did the 3-year period start to run?
I cannot answer this question. This is a question for the mining office. I am not a representative of the state mining administration. I am an expert on mining technology. The deadlines and the different stipulations of law that has to be followed by legal experts. My task was different. I was supposed to solve the technical problems, which are much more complicated.
Continue tomorrow, if you allow me.
So the cross-examination is not completed, and there will be maybe redirect from the other side. So you will have to come back to this room tomorrow morning at 9, and in between you are not to talk about this case with anyone, please. That's the rule for witnesses.
I think we also may have agreement that tomorrow we may try to end a little bit earlier, since these have been relatively long days. Counsel, you can confirm, but I think the hope was to try to end around 6-ish tomorrow.
Depends on the answer, but we will try.
Okay. And now tomorrow, after Mr. Čorej, we have Ms. Jarvis, and will they be together, Mr. Gardiner and Ms. Jarvis, or in succession?
I think they would have to be in succession.
Okay. So we start with we will start with Ms. Jarvis.
My understanding is they're presenting her first, then Mr. Gardner, then Mr. Anderson.
No, I don't think we've ever had any prior discussion about whether they'd be heard together or in succession. Our understanding is they'd be heard together since it was a joint report.
Well, the first report wasn't.
This report wasn't, but the second. Put another way, Mr. Gardner did not issue a report without Ms. Jarvis. The only report he ever issued was with her.
Or you could have her first alone and then the two together.
That would make more sense, I think.
Maybe.
If that's the case, then the questions, when only Ms. Jarvis would be here, would have to be limited to matters covered in her first report.
Right.
Okay, thank you.
Thank you.
See you tomorrow.